Good afternoon, Chairman Gray and members of the committee. My name is Rebecca Bitzer. I'm a legislative attorney with the Office of Legislative Counsel. We're a nonpartisan office providing legal counsel to the legislature, among other clients. And I've been asked to testify today as to the laws that relate to daily fantasy sports, both at the federal and state level. And I want to preface my testimony with saying that today, unfortunately, I won't be answering the question I'm sure many of you have as to whether or not daily fantasy sports is in fact legal or illegal. My testimony will be limited to only providing an overview of the legal framework that a court would address in addressing the legality of daily fantasy sports, both under state and federal law. I'll begin my testimony with an overview of those federal laws that may relate to daily fantasy sports, beginning first with the Professional and Amateur Sports Protection Act, or shortly known as PASPA, which prohibits a government entity, including a state, from sponsoring, operating, advertising, promoting, licensing, or authorizing by law, or any person pursuant to a law authorized by a state, from having any betting, gambling, or wagering scheme based directly or indirectly on either one or more competitive games in which amateur or professional athletes participate, or on one or more performances of individual athletes that participate in either an amateur or professional sporting event. And so the question as it relates to daily fantasy sports is, does daily fantasy sports fall within the prohibition of PASPA? As a matter of first impression, no court has yet weighed in on that question, and so we do not know. But I do want to point out, as it relates to daily fantasy sports and skill versus game, the congressional legislative history, the committee report prepared by the Senate Judiciary in enacting PASPA did make a point of noting that the prohibition of PASPA applies regardless of whether the scheme is based on skill or chance or any combination thereof. The next statute or federal law I'm going to discuss is one that I am sure all of you have heard of, the Unlawful Internet Gambling Enforcement Act, UGIA. And UGIA, it merely prohibits a person engaged in the business of betting or wagering from knowingly accepting certain financial transactions made in connection with the participation of another person in unlawful internet gambling. UGIA was designed, Congress intended, as to be an enforcement tool, recognizing that gambling was in fact taking place over the internet. And UGIA serves as an enforcement mechanism to enforce existing gambling laws that take place over the internet. Under UGIA, unlawful internet gambling is defined as a place to receive or to place, receive, or otherwise knowingly transmit a bet or wager by any means that involves the use of the internet, where that bet or wager is unlawful under any applicable law of federal or state. And so here, UGIA must be read in connection with any other federal or state law. And here, UGIA defines bet or wager, and this is where the carve-out for daily fantasy sports or fantasy sports comes into play. UGIA defines a bet or wager, and it as staking or risking by any person of something of value upon the outcome of a contest, and it includes any scheme of the design that is described under the Professional and Amateur Sports Protection Act. So any scheme prohibited under PASPA is included within the definition of bet or wager for purposes of UGIA. Expressly excluded from the definition of bet or wager is participation in any fantasy or simulation sports game which meets certain conditions. And if you allow me, I'm going to read those. In that the simulation sports team is based on the current membership of an actual team that is a member of an amateur or professional sports organization. All prizes and awards offered to winning participants are established and made known to the participants in advance of the contest, and their value is not determined by the number of participants or the amount of the fees paid by those participants. And all winning outcomes reflect the relative knowledge and skill of their participants and are determined predominantly by an accumulated statistical result of the performance of individuals in multiple real-world sports or other events. There are many arguments made in the space of daily fantasy and season-long fantasy sports that this carve-out is, in fact, their argument of the legality is based on this carve-out. But in doing so, it necessarily ignores another provision of UGIA, and that is referred to as the rule of construction. And in that it says, UGA states that none of its provisions shall be construed as altering, limiting, or extending federal or state law as those that prohibit, permit, or otherwise regulate gambling. Therefore, although UGA prohibits accepting certain types of payments made in connection with unlawful internet gambling, the UGA does not purport to affect any state law, any particular gambling activity that is either lawful or unlawful under a state or federal law. It is merely an enforcement mechanism for enforcing existing gambling laws. Now moving on to another federal statute that may be implicated is the Wire Act, and it prohibits a person engaged in the business of betting or wagering from knowingly using a wireless communication facility for the transmission in interstate or foreign commerce of any bets or wagers or information assisting in the placing of bets or wagers on any sporting event or contest. Now, the provisions are limited to bets or wagers or on wagering communications related to sporting events or a contest. In 2011, the Department of Justice issued a legal memoranda clarifying an interpretation of the Wire Act in that it only applies to those wireless communications that take place in interstate commerce relating to sporting events or contests. Prior to then, there was a split of authority as to whether it would be applied beyond sporting events or contests. And the DOJ specifically found that interstate transmissions of wire communications that do not relate to a sporting event or contest fall outside the scope of the Federal Wire Act. And next, moving on, in addition to the Wire Act, the Federal Travel Act is implicated in that gambling activities conducted via the internet may be prohibited. The Federal Travel Act specifically provides that it's prohibited, among other things, the use of any facility in interstate or foreign commerce with the intent to promote or facilitate any unlawful activity. And for purposes of the Travel Act, any unlawful activity is defined to mean any business enterprise involving, among other things, gambling in violation of the laws of the state in which they're committed. And so the Travel Act requires a predicate violation of a state law in order for its prohibition to come into play. And the last federal statute I'm going to touch upon is the Illegal Gambling Business Act. And in essence, it prohibits those gambling business enterprises, and that whoever conducts, finances, manages, supervises, directs, owns, or all or part of an illegal gambling business shall be punished as follows. And it defines an illegal gambling business to mean, among other things, a gambling business that is, again, in violation of a state law or political subdivision in which is conducted. It involves 5 or more persons and has continuously been in operation for a period in excess of 30 days or has a gross revenue of $2,000 in any single day. That will round out the discussion of federal law, now moving particularly onto California law and starting first at the California Constitution. Section 19 of Article 4, it establishes the parameters of legal gambling activities in the state, and there's 2 provisions in particular that I'm going to discuss. First being Subdivision A, in which it states that the legislature has no power to authorize lotteries and shall prohibit the sale of lottery tickets in this state. Mind you, there is an exception in the Constitution that does provide for the California State Lottery, but other than that, all lotteries are prohibited, and the legislature cannot authorize a lottery. And next, I'm going to refer to what is commonly referred to as the casino prohibition. And in that, the legislature has no power to authorize and shall prohibit casinos of the type currently operating in Nevada and New Jersey. Now, reading it on its face, it's difficult to see what that means, but luckily the California Supreme Court has construed the casino prohibition in that it refers to a casino of the type operating in Nevada and Jersey. It can be understood as 1 or more buildings, rooms, or facilities, whether separate or connected, that offer gambling activities, including those statutorily prohibited in California. And in recognizing the legislative intent when it was added Subdivision E to the Constitution, the California Supreme Court realized or recognized that it was designed to elevate statutory prohibitions on a set of gambling activities to a constitutional level. Under the hotel employees' decision, the decision of the California Supreme Court construing the casino prohibition, gambling activities that were statutorily prohibited when the casino prohibition was enacted in 1984 are among those activities covered by the casino prohibition, thereby precluding the legislature from authorizing those activities by statute. If on the other hand, the legislature is free to authorize and regulate gambling activities that are not in a form that's currently prohibited under the casino prohibition. So if a penal code provision at the time in 1984 prohibited conduct, then the legislature is precluded from authorizing any conduct absent a constitutional amendment. And so now speaking to the constitutional framework and now moving on to the penal code provisions dealing specifically with gambling as they relate to daily fantasy, as stated before, the Constitution prohibits the legislature from authorizing a lottery, and Penal Code Section 319 defines what a lottery is. It's an incredibly long run-on sentence, but I'll give you the 3 boiler points. There's 3 elements to a lottery. And those are prize, distributed by chance, and consideration. And this is where discussion of chance versus skill. In determining whether a game or a scheme is in fact a lottery, the question is it a game distributed by chance? And courts in California have adopted the dominant factor test. And in determining whether a game is one of chance, the test is whether skill or chance is the dominating factor in determining the results of the game. It is the character of the game rather than a particular player's skill or lack of skill that determines whether a game is one of skill or chance. Now, there have been numerous opportunities in which the courts have been able to determine whether a game is one of skill or chance. Unfortunately, they've not yet determined whether daily fantasy or season-long fantasy is a game of skill or chance. But in looking to how they've determined, for example, whether the game of bridge is one of skill or chance, I've pointed to now 5 things, characteristics of a game of skill that the courts have brought up or analyzed. And if you allow me, I'd like to read the 5 of them. The first being whether the game there's a recurring necessity of the player to make decisions and exercise judgment that considered together will ordinarily be determinative of the outcome of the game. Second, the scope of deductive analysis, psychology, and mental ascendancy over one's opponent that a particular participant must have. Third, whether a skilled player over a long period of time is more likely to win than a non-skilled player. Fourth, the actual odds and statistics against winning a contest or game. And lastly, but certainly not limited to a court's analysis of the issue, but whether the existence of a large amount of literature designed to increase a player's skill. And so these are just some of the factors the courts have considered in whether a game is one of skill or chance. Now moving on to Penal Code Section 330, these games that are specifically mentioned outright in this provision are in fact prohibited. And it provides, without having to read all of them, for example, every person who plays or every person who places a bet on, for example, the game of Monte Roulette 21 are punishable as a misdemeanor. On the other hand, the legislature has adopted, as opposed to coming back to amend Section 330 every time a new game they would like to prohibit, the legislature adopted a banking or percentage game test. And Section 330 prohibits any banking or percentage game played with cards, dice, or any device for money. And so it was designed as a flexible means of reaching 2 evils perceived by the legislature. One, in which a game, the house is involved directly in the play, the ultimate source of the funds, and secondly, in which the house plays a more passive role and has the inviolable position of obtaining profit without incurring any risk of loss. And the statutory scheme doesn't provide a definition of banking or percentage cards game, and so the courts have construed those games. And so in first, a banking game is a house is one in which the house or the bank is a participant in the game, and there is a fund against which everyone has a right to bet, and the bank is responsible for the payment of all funds. And secondly, moving on to percentage game. The court has defined a percentage game as one of any game of chance from which the house collects money collected as a portion of wagers made or sums won in play, exclusive of charges or fees for the use of the space and facilities. And so the question, because daily fantasy or any fantasy sports model is not specifically listed under 330, the question would be, is it in fact either a banking or percentage card game? And again, a game not specifically listed and not played as a banking or percentage game would not be prohibited under Penal Code Section 330. Now moving on to Penal Code Section 337A, it prohibits any person from engaging or in bookmaking or pool selling and any other specified conduct as it relates to those things. Each activity described in 337A creates a separate and distinct offense. Therefore, the same evidence may allow for a conviction under separate counts. In addition to bookmaking and pool selling, 337A prohibits, for gain or otherwise, an individual from keeping a place with materials for recording bets on contests of skills between persons or upon the result of a contingent or unknown event, from receiving any money or consideration for the purpose of being wagered upon, again, an outcome of a contest of skill between persons or on the outcome of an unknown or contingent event, from either recording or registering a bet or wager, allowing a place to be used for any of the purposes otherwise prohibited in 337A, as well as for making or accepting a bet or wager upon the outcome of a contest of skill between persons. Related to 337A is Section 336.9. Now, any violation of 337A is a misdemeanor or a felony. 336.9 of the Penal Code serves as somewhat of an exception to that misdemeanor felony, and it makes a violation of any of the activities described in 337A, save for bookmaking or pool selling, in which a participant, other than the stake under the conditions available under the game, not for gain or otherwise, they place a bet or wager or a betting pool or pools are made between persons for the purpose of placing a bet or wager on a contest of skill between persons. It's an infraction. And this scheme, this statute, was designed, as evidenced by the legislative history, to get to those office pools, those March Madness brackets, in which you have a small number of individuals engaging in pool selling or in placing wagers. But the legislature said, should these individuals truly be punished as the misdemeanor or a felony? Now, this infraction violation, it doesn't apply under two circumstances. One, in which the bet or wager is made online, then 337A would fall into play if any of the activities you engage in are in fact prohibited. And secondly, if the betting pool is more than $2,500, you would be in fact not fall within the infraction violation. Now, moving on to the Gambling Control Act. And the Gambling Control Act, it provides for the regulation and licensure of authorized gambling activities in the state of California. The California Gambling Control Commission licenses gambling establishments, and the investigation and enforcement of those provisions lies with the Department of Justice. Now, enacting the Gambling Control Act, the legislature intended to set minimum standards for the regulation of permissible gambling activities. And it provides that any person who operates a controlled game, which is a defined term in law, is required to obtain a license. And Penal Code Section 337J makes it unlawful for any person to offer a controlled game without first obtaining a license under the Gambling Control Act. Now, controlled game is defined to mean any poker or pai-gow game and any other game played with cards or tiles approved by the Department of Justice, and any game of chance, including any gambling device played for currency, check, credit, or any other thing of value that is not prohibited and made unlawful by state or local ordinance. And so now that rounds up my testimony today. I'm more than happy to answer any questions you may have.
Okay, thank you to all of the panelists. I'd like to put a couple of questions out there. First, for Mr. Grove, you covered esports, and I think that might be an area, I think many on the committee and certainly throughout the committee are somewhat familiar with fantasy sports. Esports seems a little less well understood. Could you maybe provide a little more detail?
Sure. Esports is essentially competitive video gaming, and you'll see it played primarily around a few titles: League of Legends, Defense of the Ancients, Hearthstone, other words that mean absolutely nothing to the people that I'm speaking to, and really don't mean much to myself either. But it is, for that difference, that cultural difference aside, daily fantasy esports is effectively the same as daily fantasy sports. You pick a roster of athletes, and your roster is scored based on the performance of those athletes in competitive video gaming activity, and then various rosters compete based on those scores. It is something of a niche activity, but it's growing at a pretty rapid clip. We estimate that the daily fantasy esports segment was closer to $20 to $25 million in entry fees in 2015, but notably that those entry fees were spread across some 500,000 to 600,000 active players. So a tremendous amount of interest in terms of player numbers, but not nearly as much volume in terms of entry fees.
Thank you. And for the deputy, you went into some detail about the predominant factor test that we use here in California. And as I understand it, different states have different tests. Is that correct?
That's correct.
And I know there's been a lot of comparisons drawn, a lot of discussion about what's going on in New York. Does New York use the predominant factor test?
New York defines game of chance, and if you may allow me, if I can read how they define that. Contest of chance means any contest game, gaming scheme, or gaming device in which the outcome depends in a material degree upon an element of chance. Now, speaking to New York law, of course, while it's very interesting to see what other jurisdictions do, truly any decision of a New York court would not be precedent for a California court. And so that it is another body of law. In determining whether the legality of daily fantasy sports under California law, it would be the California body of law that would inform that question.
Right, so each state has this unique standards and tests, and therefore we shouldn't draw any conclusions really based on
I would
New
agree
York
with that. Yes.
decisions. You made reference game of skill, game of chance, percentage games, and lotteries. Under the penal code, can either a game, a lottery, and/or a percentage game, can it be defined that way if, in fact, it is determined a game of skill?
As I stated before, lottery has three elements, one of them being the game is distributed by chance. If it is, in fact, a game of skill, it cannot meet one of the elements under a lottery.
Or a percentage game.
And again, you're correct with the percentage game. A percentage game, the court defined it first being any game of chance in which, now I don't want to misspeak my words, so if you afford me, any game of chance in which the house collects money calculated as a portion of the wagers. So if in going with the definition provided and used by the courts, if it's a game of skill, even if the prize, the house were to collect money calculated as a portion of the wagers, if it were a game of skill, it wouldn't fall within the definition of percentage game.
And would I be correct to say that there's no universal test for quantifying a game of skill versus a game of chance?
It's a very fact-intensive inquiry. While it is a question of law, it's a fact-intensive inquiry. And other than the test employed, the dominant factor test in California, I can't say that there's a universal test.
Okay. Do we have any additional questions from the members? Seeing none at this time, I'll thank our panelists for your testimony. We're going to make a slight adjustment to our agenda. As those of you that are following along at home, the industry perspective on daily fantasy sports operations is the next panel listed on the agenda. We're actually going to take the relationship between daily fantasy sports and professional sports teams panel at this time. So those of you who are sitting on that panel, if you'd please approach and join us. thank you all for being here. I want to make a quick note that we've got a number of folks bringing a team perspective from professional sports teams. You all are here to testify for the committee and provide background information on the relationship between your teams, your business model, and the DFS world, not necessarily to discuss the legality or the skill versus chance element that we discussed in the previous panel. Proceed.
Thank you. My name is Pete Gerson with the LA Clippers. Thank you, committee, for the invitation to come here and speak. The Clippers, as an organization, we embrace technology on and off the court. On the court, we've gone to great lengths, like a lot of teams in the NBA, to study advanced analytics and how it impacts the game. We're also, on my side of the business, which is the business side, how do we use technology to advance interest and engagement and passion amongst our fans. The DraftKings relationship with the LA Clippers is instrumental in advancing this goal. The way our fans consume the game and the interest in it, the partnership has certainly helped bring that engagement about. This partnership garners greater fan interest in the sport, Clippers player performance, and individual stats.
We're going to interrupt you real quick. I notice we've got a handout. Do we have this available on PowerPoint as well for the audience, or just the handout at the moment?
I can make it available as soon as I can.
Okay. Yeah. Thank you.
It is also our hope and goal that the advanced interest and engagement will help on broadcast impressions and interest as well. As I don't know if the committee, if you're from the Los Angeles area or not, but our fan base is rapidly growing, and it's comprised a great deal of millennials and youth that are coming on board as Clippers fans. DraftKings is aligned with this demographic's desire for second screen content and tip of the finger information that keeps up their sophisticated interest in sports. Strategically, the Clippers are continuously pursuing new platforms and formats that offer our fans deeper engagement with our player and team, particularly through advanced analytics. It's been our feeling that the fantasy sports and daily fantasy and DraftKings and what we're involved with them has helped deepen our fans' association with our players and promoting the value of analytics around our game. I had a couple examples. The one that was handed out was something we launched around the playoffs last year, which we won't talk about who ended up winning that playoff championship. But it was ClippersIQ.com, which was a digital hub that we created, again, to kind of bring the analytics that we use to analyze what happens on the court and how our coaching staff and individuals tied to the basketball operations side look at the sport. This hub helped bring that to light to the consumers, just to follow the game at a deeper level. It was highly engaged, a lot of interest from our fans. We're continuing that this year, and we'll ramp it up in further detail. Another promotion that we've run this year is around our starting lineup. DraftKings is the partner of that. We promote that through our in-arena, through our broadcast, and through our digital channels. It's been one of our number one engaged fan social media posts. We measure that based on our own analytics that measure engagement, not necessarily impressions, but how many fans retweet it, post it, comment on it. And it ranks as one of our top performing fan engagement social media posts. In addition to the analytics, the partnership with DraftKings has delivered once-in-a-lifetime experiences and other benefits for Clipper fans, such as away game road trips, playoff tickets, giveaway T-shirts, meet and greets. That's what I conclude with my comments on the committee, and I think I pass it to Nick.
Perfect. Thank you.